Right, Miss Hutton.
Thank you, my Lord.
Round 3, I think, isn't it?
My Lords, may I just start with Article 31 of the Senior Courts Act?
Oh, yes.
My Lord, the first point is that it doesn't apply, because it only applies to
Oh,
judicial
because
reviews.
we're not into that area, right? So that's the end of that then, yeah.
Right. Unless your Lordship wants any further comments on discretion. No, okay, I'm grateful. So, my Lord, ground 3. My Lords will be aware that the statutory framework for the Respondent's decision is in Section 1 and Section 22 of the Road Traffic Regulation Act. And, my Lord, turning to 122, which is on page 24 of the Authorities Manual.
Yeah.
And one sees the duty, which is qualified by the word so far as is practicable, to secure expeditious, convenient, safe movement.
Can I have the section numbering?
Apologies. 122, my Lord, page 24.
You. Well, I seem to have a differently numbered authorities manual to everybody else. But
It's page 24?
no, it's page 14.
Oh, yeah.
Apologise for that, my Lord.
I'm struggling on manfully, but
Right, so
if I pester you with a request for references, you'll know why.
that's 122, yeah.
That's 122. And then also relevant is tab 2, the Traffic Management Act 2004, section 16, the general network management duty. And again, it's a qualified duty, and sees in the second line, so far as may reasonably be practical, having regard to other obligations, policies and objectives, the following objectives: securing the expeditious movement of traffic and facility on the authorities' network. So, well, those were two duties which applied in relation to the making of the order. If I could then turn to the orders, I turn to the officer's decision. The report at tab 10, the supplementary bundle, page 150. Yes, page 150.
Yep.
And it's section 6 where the justification for the order is made. And if I could deal first with congestion, journey times, then with safety, and then with carbon. So on congestion and journey times, the officer's report at paragraph 6.3, third sentence, so it's the end of the third line, the benefits of the proposals are that they will create improved infrastructure for all road users by making better use of available highway space in the interest of balancing needs of all vehicles. Currently, highway arrangements prioritise motor vehicle. To rebalance this priority, mitigation is also required to maintain the expeditious, safe and convenient movements of these private vehicles through the network. And then at 6.4, the fifth line down, it will enable the council to comply with its duty, section 122 duty, to exercise functions.
Yeah.
See that, my Lord?
We've read all of that, yeah.
Yes, read all of that. And then the final part will enable the council to carry out its network duty to secure expeditious movement. Also relevant is Appendix B to this report. And Appendix B was where the officer set out objections and then comments in response. It starts on page 196. I'd ask your Lordship to turn to page 207.
Yeah.
This is part of a response to the appellant's objection, where concerns were raised about both congestion and journey times. And one can see the response in the second and third paragraph in the right-hand column. I'll ask your Lordship just to look at that.
Yep.
So it acknowledged that the previous scheme would lead to delays. Modified scheme will seek to allow for more efficient flow, and then a reference to bus journey time savings. And my submission, a fair reading of the report, is that there is no mention of any additional congestion or queuing by general traffic, and there's expected to be bus journey savings, and one can see that at 207, but also one can see it in the at 6.2, page 151, and the reasons for making the orders. So at 151, paragraph 1, the reason for making the order is an improvement of bus journey times.
Where is that?
Page 151, paragraph 1.
Oh, yes, okay.
And paragraph 2. These are addressing the purposes for each order. So improvement of bus journey times. In my submission, my lord, this left out of account the WSP traffic modelling, which I've shown your lordships, which was an overall disbenefit to general traffic. And also, it failed to give the full picture in terms of the impact on buses, which the council accepted were implicitly captured in the WSP report, and also no benefit overall. So, my lord, that technical evidence was not only not reported in the officer's report, but in my submission, the officer's report was misleading because it gave the impression that the expediency of movement for vehicles would be maintained, 6.3 and 6.4, and that the only relevant factor when it came to buses was an improvement in journey times. So, my lord, my submission, those statements in this report were 1, unsupported by adequate evidence, 2, materially misleading, and 3, left out of account, and obviously material consideration, which was the WSP report and what was known about bus journey times. So that's the short point, and I'll if I do with each topic and then come to the judgment. That's all right. On safety, my lord, paragraph 6.3 and 6.4, by reference to the duty, so the 6.3, bottom of page 151, mitigation required to maintain expeditious, safe, convenient movement, and then 6.4, again by reference to the duties, stating that this would secure safe movement of vehicular and other traffic. Halfway down the paragraph, by reference to the 122 duty. But, my lord, nowhere in this report was it acknowledged that the interested party harboured a critical safety concern about the proposals. It's correct that overall the quality assessment panel concluded that there would be improved safety measures, but there was one critical element which wasn't reported to the decision maker. And in my submission, they're leaving that was an obviously material consideration because this scheme had been through critical analysis by an independent body which had reached that final conclusion. And the existence of that safety concern was highly material in light of the 122 duty, which specifically requires safe movement. So in my submission, that was obviously material left out of account, and the report was materially misleading in failing to report. Third, my lord, is climate change and carbon impact. Page 153 of the report, section 11, is where the report dealt with climate change. I'll just ask your lordships to remind yourselves of that paragraph.
Yep.
So this relied on Appendix E. Appendix E starts at page 84, climate change impact assessment.
Yep.
So we see the description of the proposal on 228.
The page.
228. So the description is amending TROs in order to be able to deliver the PCF project. And then the assessment, and if one turns to page 230,
Yep.
emissions for travel were said to be positive.
Yep.
And then the negative was from construction on this qualitative analysis. And then in the summary at 234, overall neutral impact, any negative impacts likely to be temporary, occurring during construction period with positive impacts anticipated through longer term travel changes using sustainable modes.
Yep.
But nowhere in this qualitative assessment or the report was it drawn to the decision maker's attention that in fact there was a quantitative assessment that has been carried out. I think the date of the report was 13th of December. The decision wasn't made until the 10th of January. The WSP carbon report was dated December 2024. And my lords, as I've shown your lordships, that predicted that even when one looked solely at user emissions, one ended up in a negative carbon scenario, even without construction. And so, my lord, in my submission, that was obviously material. It was a matter, carbon impact was a material issue. The council had in its possession technical evidence which estimated the impact of the proposal over a 60-year period. And in my submission, that was obviously material decision was left out of account. And the report, by adopting a qualitative proposal, a qualitative assessment, which simply, well, construction emissions would be offset by user emissions, was materially misleading.
Adopting a qualitative approach that construction impacts offset by what?
The construction would be short-term and offset by user emissions, i.e. the modal shift, to end up in a neutral impact was materially misleading. And it was contrary to evidence that was currently that was in fact before the council.
Hold on, left it out of account, point 1. 2, by adopting a qualitative approach, was that materially misleading of the submission?
Yeah, the report was materially misleading by failing to draw the decision maker's attention to the.
And your point 3 was?
Sorry, point 1
Left out of account.
Obviously, into consideration, materially misleading. So no, it's those 2 points.
Those 2, okay, thank you.
My lord, turning to the judgment below.
Yeah.
CB9. Page 121.
Yep.
The discussion of the fifth ground starts under paragraph 58. And then picking the reasoning up at 61. So the applicant says, in relation to highway safety, bus journey times, general traffic congestion, air quality, carbon impact, there is required to be expert technical assessment. As a ground of challenge, this rather loses impact in view of the fact not only was there expert assessment, the applicant accepts there was. Well, the point being raised was not that there hadn't been expert assessment, it was that expert assessment hadn't been taken.
Well, no, you said 2 things actually, and you still say 2 things, I think, in your grounds. you say they should have had it, but there you say there wasn't, they didn't take it into account.
Yes, my lord.
Yeah.
And so the judge
So it's understandable, the first part, but it doesn't go to what you're now addressing, yeah.
So my lord, then the judge accepts that some of those topics would require expert assessment.
Help me a bit with what you're pointing to in 61.
So my lord, 6 lines down, the first point is that although some things under these heads may require such assessment for any claim about them can be made, doesn't not apply to everything.
Yeah.
So, my lord, my submission, the judge simply didn't understand the point. The point was not that the revised station gateway scheme hadn't been subject to technical assessment. The issue was that those technical assessments were not taken into account as part of the TRO process. So the TRO process was looking at those issues as well, and it had not been informed by expert technical assessment. And my lord, in my submission, where one is dealing with instituting a one-way system, for example, the effect that will have on traffic movement can't be, will have to be the matter of assessment, technical assessment, for example. Equally, whether your user, where you end up on your predicted user emissions is also a matter for technical assessment. Will your user emissions outweigh the carbon it will cost you to construct the scheme, for example?
Yep.
And equally, the issue of highway safety, similarly, it's a matter of expert technical assessment. But my lord, so the point was that TROs, that had not been factored into the TRO decision, but it was done for the wider scheme. The judge then went on at 62 to conduct a tame analysis. But my lord, the expert assessments were before the authority; they were in its possession.
Yep.
This is not a Tameside point that additional evidence had to be sought out. The reports were in the authority's possession. Paragraph 64. Well, the judge appears to be under the impression that those reports that I've shown your lordships, the expert technical reports, were taken into account as part of the decision in my submission. If one looks at all of those 61 through to 67. In my submission, that was wrong. And it's not clear, paragraph 64, what is meant by partial view of the evidence, misreading of it, misunderstanding it, or attempt to rely on the TRO's evidence about the scheme as a whole.
Yep.
Well, in paragraph 65, the judge addressed the carbon impacts. We see at the third sentence, the report took into account the more recent assessment and recognised the problem, maintained the aspirational elements of the scheme which tend to render any current assessment irrelevant.
Was the appendix that you've shown us one that came after the report that you showed us this morning?
No, my lord. So
the one at the end of the report, Appendix E, came before. Appendix
E, just check if E has a date on it. Yes, so it's the 27th of November 2024, page 90.
So Appendix E is the 27th of November?
Yes, 2024.
And the document you took us to this morning?
The WSP carbon report was December.
This is December 24, isn't it?
The 4th of December, page 128.
Yeah.
So the report didn't take into account the more recent assessment for the authority. Well, the second part of paragraph 65 deals with the provision of the bus lane and improvement of journey times. And there was a disagreement about whether there was evidence as to whether the bus lane would improve journey times or not. But the wider point was that there wouldn't be an improvement overall.
And by overall, what do you mean?
Well, the report solely referred to improvement of bus journey times into the station. But as I showed your lordship in the agreed note, some routes would benefit, some routes would disbenefit. Overall, it was neutral.
But it was neutral, okay.
But the report gave a one-sided.
Is that all of when you say routes? Is that of all routes going to the station, or of all routes navigating the urban area?
My understanding, my lord, is that it would be the latter.
So all routes navigating the urban area.
So for example, the bus station is to the north of the bus lane is to the north of the station. So a bus travelling into the station will use the bus lane for the 34 metres that it has it.
36.
36. 36 into the bus station. When the bus has to turn out of the bus station, that's where it hits junction 4, which has been dealt with in the WSP report, and it melds with general traffic. So my understanding is that some routes would benefit. It may be it's those ones to the north.
But there could be bus routes that simply don't go to the station at all. I'm not sure whether they are included in your assertion, or not assertion, your agreement, I should say, about the impact on bus routes being neutral overall.
My lord, there were lots of questions back, and there were requests for information from the then claimant to the appellant about disclosure and candour, etc. We ended up with the agreed note, and so as far as I can. I'm not tempted to shoot the messenger. Don't worry. No. But
I'm just trying to interrogate what this information actually tells us.
What it tells us in my submission is that the work done as part of the revised scheme was reported as showing effectively a neutral impact. Because some routes benefit, some routes disbenefit.
And you say that's contradicts paragraph 65, so you must have made an error. Yeah.
So, well, no, my lord. 65, the reference is to there being an issue about whether the bus lane would increase journey time. There was that issue, but the wider point, the ground, was actually the report was misleading by only reporting benefits and not.
And I haven't understood you.
No. My lord, the agreed note before the court was that the evidence showed
there's a neutral overall impact.
The report had not said that. The report had, when it referred to bus journey times, it only did so in the context of improvements. And in my submission, a fair picture would have been a neutral one.
So the report was misleading.
Misleading.
Okay. Thank you. So that's the 4 points then, is it?
So that's 65, 66, my lord. The judge says each of the points. So if I could ask your lordship just to remind yourself of paragraph 66.
Yeah, I just read it, yeah.
And the judge says, well, each of the points said by the applicant were dealt with in the report. My lord, my submission, yes, the topics were dealt with. Topics of congestion, safety, carbon, dealt with, but not the technical evidence which the council had available to it.
Yeah.
And my lord, that same error feeds into the remaining part of the judge's reasoning on this ground.
Yep.
So, my lord, in my submission, the judge was wrong to dismiss 1 and 3 for those reasons. My lord, those are my submissions.
Any questions? That's very, very helpful. Thank you very much. Right, Mr. Riley-Smith.
Good afternoon, my lords. If I may just grab the...
Oh,
Thank you, my lords. Good afternoon. If I may first just deal with the housekeeping matter your lordship referenced at the start in relation to the unagreed bundle.
Oh, yes.
Yes. My lords, my apologies for the confusion on that. That was originally put in by the respondent to allow for the court, as it were, to have judicial regard to the fact that TRO 5 has been made. My apologies, this message hasn't got back to the bench, but a couple of weeks ago, because it was resisted, it was agreed that application wouldn't be maintained as long as the appellant accepted. The court could have judicial notice of the fact that TRO 5 had been made.
It's not, well, I suppose we can look it up on a website, can we? I mean, okay, so we don't need to deal with this application, and it's accepted that if we go onto a website, we will find a document that's TR 5.
And you can have regard to the fact that it has been made, albeit it's been challenged, as my learned friend has noted, but TRO 5 was made following this decision. My lords, as set out in my skeleton, there are in effect three fundamental flaws to the appellant's case, and the answer or the recognition of each of those flaws provides a complete answer to the appeal. In relation to the ground 1 and in part ground 2, the fundamental flaw is the submission that the TROs implemented, either in whole or in part, the scheme. They did not, neither on the terms of the November 2023 resolution, nor in any practical sense on an understanding of what implement means when used in the resolution. And that wholly addresses ground 1, because if the schemes have not been, or sorry, I should say if the scheme has not been implemented, then that trigger for public engagement does not arise. The second flaw.
Hang on,
Yes.
you say they don't. I think a lot of this, I'm afraid, is just language. If one doesn't start with labels, particularly ones that you like, because they favour one side or the other, the state of affairs is, using modern jargon, for the thing, which we call the scheme, to be delivered, i.e. for roads to change, people to be hopping on and off buses and racing up and down on cycles. A number of things would have to happen. Funding, TROs. The TROs are part of the process by which the thing will be delivered.
Mm-hmm.
Is that right?
Yes, my lord.
Okay.
But to take it one point further, it can't be delivered with TROs alone.
No, but it's part of the process of implementation at the very minimum, wouldn't you accept?
Yeah, I use the term facilitating, but in terms, and that's the term used in the
Bringing about a state of affairs in the universe where people can use a bus lane in Harrogate. Is that okay?
Yes, my lord.
Yeah. They're part of the process of bringing about the desired state of affairs.
Yes.
Yeah.
That flaw also in part addresses ground 2, because the irrationality arguments in relation to ground 2 are again predicated and phrased on the basis that the scheme has been in part implemented. The second fundamental flaw is to entirely ally the TROs with the scheme. The scheme is a larger scheme than just, as it were, the legal changes to the road network in terms of bus lanes and one-way systems. It includes other elements which aren't associated with the TROs. That's public realm improvements, but that also includes elements to do with traffic, like changing traffic light signals and elements like that. TROs restrict the flow of traffic on a network.
So the scheme is larger than, but includes the matters dealt with by the TRO.
Yes.
You mean by that the the alteration of the timing and management of the traffic signals
Yes.
to make sure that they are working more efficiently?
Yes, and that will in part be relevant for when we come to consider what the traffic modelling on the scheme showed.
So the first flaw is
Reference in the papers to mover, which my colleagues may not have heard of, but which those who bear the pain of public inquiries on these matters are very familiar with.
the first flaw is that it's wrong to say they implemented the scheme in whole or in part, although they were part of the process of bringing about the desired effect. The second flaw is it's wrong to elude the TROs with the entirety of the scheme, because the scheme is larger than, but includes the matters in the TRO. Yeah.
And therefore you can't simply read across, as it were, evidence and decision making that relates to the scheme and automatically apply it to the more narrow decision making that was going on in relation to this challenge.
Well, that's important. Yep.
And the third fundamental flaw, sorry, I should say that second fundamental flaw goes primarily to ground 3.
Ground 3.
Well, it probably also touches upon ground 1 and ground 2. But the third fundamental flaw is to, and this solely relates to ground 3, is to focus narrowly on specific issues such as congestion or bus journey time, without recognising the wider balancing, section 122 balancing exercise and judgment that was being formed. And in focusing on small parts, it ignores, especially given the latitude arising from the Trail Rider Federation case, the latitude given to local authorities in exercising that judgment. And my lords, I will go on to expand and apply those.
Yep.
That I also want to ensure that I'm answering each specific criticism, but I do say that those 3 points address the claim.
Right. Okay.
My lords, I don't wish to take too much longer on facts, other than to highlight really just a few points. The first, and I'm at paragraph 8 and 9 of my skeleton, is to highlight that one of the ways to distinguish between the TROs and the wider scheme is that they are under separate decision-making processes. The scheme, which, as I'll return to, the principle of which was established in November 2023, had, at the time of the TRO decision, 2 further formal decisions that had to be made before it could be implemented. The first was for the council to decide to accept the funding, the TCF funding, and enter into the contracts. And the second decision was for the West Yorkshire Combined Authority to give what's called approval to proceed, ATP, to the final version of the full business case. That is set out in more detail on the witness statement of Mr. Mason that I don't intend to take the court to. I don't think there's a dispute about this. But therefore the TRO decision was not the final decision in relation to the scheme. And just to inform the court, because it's an important correction to my skeleton, which was correct at the time of drafting, is not correct. In relation to the council's decision to, well, no, let me take it a step back. It remains the case that the combined authority have not yet given the final approval to proceed. So one decision still has not been made in relation to the scheme.
Yeah.
In relation to the decision to, as it were, accept the funding and award the contracts, that decision has been made provisional on ATP being granted. It was made on the 18th of November.
Hold on. Of 25 or 24?
25,
Yeah.
And this is referenced at paragraph 10 of my skeleton. The correction is at paragraph 13, I say there's been no challenge to this yet. To inform the court, the appellant has now brought a challenge to that decision.
To which decision?
To the decision to accept funding and award contracts. The decision I reference at paragraph 10.
Right. So a decision of the 18th of November.
2025.
Right. So we've got the challenge to number 5 traffic order, and we've got a challenge, we're told, we haven't seen it, to a decision that's JR, presumably both of those. No, JR.
So the TRO is a statutory challenge.
And this is JR.
The 18th of November is and that includes a challenge as to a lack of consultation.
Right.
So, factually, and again, my lord, this is just confirming your encapsulation of the point, the TROs are a smaller separate prerequisite of delivering parts of the scheme. If I may just deal with, so the court has it with clarity, the respondent's position as to the November 2023 resolution. Firstly, to answer your lordship's question as to paragraph 415 and the options, if I may say.
Yeah.
The respondent's position is the executive were approving the principal scope of the scheme. So it was, as it were, at the start of the day, your lordship's understanding that was setting in the principles of the scheme at that point in time.
Always the words that interest me, because I thought it was the scheme, but you're saying the principles of the scheme, and Ms. Sutter was talking about development things. What state of affairs are these words meant to describe the principles of the scheme? Or put differently, what other things have to be decided before going up and down this road changes?
Yes. So this is setting in place that, as it were, that a scheme containing those elements at 415 will be brought forward and given approval for that. The, as it were, detailed design. Sorry.
Hold on a moment. It's the words. A scheme containing those elements will be brought forward. Hold on. Because somebody has to take a decision to go ahead with it, or because that is the decision, they are going ahead with that scheme. Brought forward, yes, makes me think that it's going to be put forward to a committee to decide.
No. On the terms of the November resolution, that is the scheme to be implemented.
So let me test it another way. If I did something else, and I added traffic order 7, a zip cord across Station Parade, that would not be authorised under this decision. And they couldn't do it, because it's not the scheme.
Similarly, the reason I posed the thought, if, as it were, it was to, as it were, change the scheme to provide a zip cord and call it the scheme, no. But if it was, as it were, additional to the scheme, for every matter that requires a TRO, you don't always need to go to the executive and, as it were, in that way. The reason for the approval in this way is this was a large multi-million-pound town centre scheme of various elements.
All I'm trying to get at, really, in simple English, is this the scheme? Once they've done everything, the funding, the TROs, the public outcome, it'll be built as said, or is it a different exercise? Yes, we like the sound of this alternative scheme. Go away, work it up, bring it back, and we'll let you know then.
Let me be clear on the answer.
Yeah.
No, it's the first one of those. If the full business case is approved, if the terms are acceptable, if rather than do it from memory, I'll do it in relation to each of those elements. But in fact, there's no further approval before those provisos being met within the resolution.
So that if one goes to paragraph 415 on page 9, which is the reference that my Lord or Justice Lewis has been referring to, there are set out there, I think, 7 bullet points of the elements of the revised scope of the scheme. Now, there may, I think, from what you were saying earlier, be a need for further details. For instance, a landscaping scheme for the public realm, street furniture, details in relation to the treatment of road surfaces. Are those things coming back for approval, or are they things which are within the scope of what has been resolved to be approved in this decision?
They're within the scope, and that's also perhaps shown by relation to 8.1 in the report.
So it's the detailed designs that have got to come back.
Yes, but the detailed designs don't go back to this executive, as it were, for revisiting the principle again.
No, it's to check, yeah. So to look at 415, I wrote in and said, could you send me a mock-up of the public realm improvements to One Arch? And you wrote back saying, no, we can't afford it, it's not happening. That would mean the scheme wasn't being implemented in accordance with the requirements. And if I said, could you show me the parking, the cycle parking facilities, you wrote back saying, no, people will have to carry them home with them. We can't afford to build a parking place. Then the scheme would be in breach because it's fixed that there's got to be public realm improvements, there's got to be cycle parking facilities as outlined. That's what you're telling this court.
My Lord, on the terms of this resolution, yes.
Right, okay.
Can I explain, so there's no suggestion, because I want to be careful with this, that I'm not being clever in my answer on the terms of this resolution. The reason I say that is the decision that I referenced on the 18th of November 2025, in fact, given this challenge and things, took the precautionary approach of saying we're going to, as it were, revisit these things afresh rather than rely on this resolution to ensure that there's no complaint about what we've done. So, as it were, the future decision on the 18th of November says we're actually going to accord a fresh, as it were, principle to ensure we don't need to do, the report expressly says we don't need to do this, but we are going to, as it were, consider things afresh and confirm that the executive's view is still that this scheme should be delivered. I don't want to be, I hope I'm not to be taken to be misleading the court. That's nothing to do really with this decision, nor this resolution. It was done on a precautionary basis because we envisaged a further challenge being brought.
So if 415 had been worded differently, and we can all write documents differently, it's not a criticism, and it said the elements that are in the revised scope scheme, which have been discussed with local members, are the following, it would be clear, and you're telling me that's what 415, or at least that's what the resolution is. The resolution is to approve those elements that could be, and you say on the resolution, have now been included in the revised scope scheme.
Detailed design.
Yeah, subject to detailed design. Yeah. Okay, that's great.
So
Thank you very much.
Sorry to be pernickety, but there's 7 bullet points. The second one is the possibility of a southbound segregated cycle on Station Parade. Does that mean that that element is still optional?
So Well, I know it's been included. I appreciate we're focusing on the words rather than these elements, but I would read that as saying that, as it were, the scheme should explore and include a southbound cycle.
That's the one in TR5, is it?
Yes. Yes.
Yes, which is the one that Miss Hutton was telling us about.
If that's the case, then the answer to TR5, perhaps, maybe, I don't know. I mean, it's so very difficult. It's unusual for a court to be asked to do metre-by-metre assessments, almost, of a station outside, a station on a street. I mean, if I listened carefully, I got the distinct impression that you couldn't have TR5, so you couldn't have TR1 to 4 without TR5, because TR5 says you can park on that area of land, which, should TR1, 2, 3 or 4 ever come into effect, would be designated a bus lane. So how can it be a possibility? Because you've got to have TR5, haven't you? Or is it two different?
Well, I think they're both wrapped up into TR5, aren't they? Not simply
the bus lane and taking away the parking.
The cycle lane and the parking are all wrapped up in what's proposed by TR5.
So you've got to have a TR5 to take away the parking, and it may or may not include a bus lane, a cycle lane, a southbound segregated cycle lane.
So the southbound segregated cycle lane is being provided by TR05. I think TR05, if my learned friend is correct, also includes elements that, as it were, stop up restrictions that would then allow the bus lane to be provided.
As a matter of words, there's nothing in this document or this resolution which would inform the reader, or indeed the court, whether a southbound segregated cycle on Station Parade is or is not required under the scheme. If it were included, it wouldn't be a breach of the scheme because it's contemplated. If it were not included, it may also not be a breach of the scheme. Is that the position we arrive at?
But my lord, again, I want to ensure you've got a clear answer. I hope it's been a clear answer to assist as best I can. But I would also make the observation that in the context of this challenge, which is to these TROs, I don't say this point is that we're critical.
No, but the meaning of the resolution is critical. And it's helpful to know whether this was a go away, think about it, and come back and tell us in a couple of weeks what you'd like, or whether this is approved. Because what the resolution was doing may throw light on the other parts of it.
Yes, my lord, and if I may be absolutely clear, and I can be clear on that submission, the resolution was not envisaging come back again further down the line with a detailed design which we'll approve again.
Well, they were envisaging coming back to the detailed design.
But not to the executive.
But not coming back with the principle, yes. Yeah. Oh no, the detailed design is going to go to the corporate director. I see what you mean, yeah, okay.
Yes. And also, of course, it has to be approved by the full business case has to be approved by the combined authority. My lord, then turning to the wording of the resolution, just again so you have the clear stance of the respondent on this. The appellant's ground one is predicated on reading this resolution as requiring a public engagement to have occurred before the TROs are made.
Yeah.
And my lord, we would say that isn't, the words cannot bear that meaning for a number of reasons. Firstly, the satisfactory TRO outcome is just one of a number of preconditions to which public engagement is a separate precondition. And so the appellant's rewording of this turns the public engagement into a precondition of the precondition. In reality, as I think my learned friend eventually reached, it all hinges on this submission that the TROs have implemented the scheme and therefore every single precondition had to be met before the TROs were made. And I'll come to the practical difficulties with that submission, but just on the terms of the wording, it doesn't sit comfortably with the fact that there also needs to be approval of the full business case. There also needs to be an acceptance of funding. And all of these are phrased as separate to the TRO requirement. While I think it's fair to note, as the learned judge in the court below noted, that the grammar of this resolution is not entirely clear, these preconditions could be said to kick in when funding is accepted or when the scheme is implemented. The point the judge below made and we adopted, that's not relevant to this case because on the respondent's case, neither of those triggers have occurred. Funding had not been accepted, nor had the scheme been implemented at the time of the TRO decision.
I think it may ultimately, or one issue may well be what the word "the scheme to be implemented" means. Now, Ms. Hudson has advanced her submission as to why, once you've made orders, you have legally implemented the scheme.
Yes.
And therefore, she says, given that, everything else must come before. But if the word "the scheme to be implemented" was not intended objectively to convey that state of affairs, but it was meant to be, to use the jargon, delivery, then it may be different. So what do you say the word "the scheme to be implemented" means?
My lord, the scheme to be implemented means delivery.
So before delivery of the scheme, you should reverse it. In order to implement the scheme, the following should happen, is what it should have said. Or let's stick to the jargon. In order to deliver the scheme, the following should happen. A, B, and C, and you say that's how we should read it.
And I'm touching on my submissions on the ground, but let me make them now. That makes sense because in the world we're in currently, on the appellant's interpretation, we have implemented a scheme which doesn't have funding, which the contracts haven't been entered into, where no works have been carried out, where, as the appellant notes, at the time of the decision, TRO 5 wasn't in place. It's hard to see how, in any practical sense, this scheme has begun to be delivered or has been delivered. And to pick up on a point your lordship raised, if I may, the TRO consultation requirement is doing a specific job, which is to consult formally on what the TROs are going to deliver. It would be odd if you had to publicly engage before making the TROs, because what is that adding? Public engagement relates to the wider scheme. That's why it's there. I will come back to this point and make sure I address it carefully, but this is where the appellant's submissions really hinges on this legal argument that because the TROs are in force, and I'll use whatever that word means, the legal effect means the scheme must be implemented. That is the foundation block for this submission.
I think it's more the scheme is implemented.
Or is, yes.
Yeah. And in fact, it's the making of the orders I think we got to at the end of the day.
Yes.
Because that's what implements them, because thereafter the argument is it's implicit that there's a duty to give a date and a duty to put the sign.
And I'll deal with all of that, but that.
Would you say that's not the real world?
Well, I not the real world, but also the resolution doesn't make sense, because if the making of the TROs implemented the order, why would you make it a precondition of the scheme being implemented?
Yeah. Right, yep.
My lords, if I may just briefly deal on the law and to focus on some elements that haven't been touched upon. The first point is, again, just an important point I make the court aware of, which is both, in fact, myself and my learned friend refer to the case of Hawes in the High Court. I'm at paragraph 24 of my skeleton.
Yeah.
And the judgment or the paragraphs of Mr. Justice Fordham in relation to the role of the court, it has since been overturned by the Court of Appeal, that judgment. We should both make the court aware of. However, those observations are not original to Mr. Justice Fordham about the role of the court and the appreciation and latitude given to local authorities, and in the Court of Appeal's judgment, they don't question or disrupt those principles. So important we make the court aware. We don't say that.
There are Court of Appeal cases that haven't been overturned, which make the same point, and they might have been a better source of reference.
Yeah, I think it was because of the context in which they were. Because we are going to come on to discuss points on evidence and the requirement of evidence, if I may just briefly reference the case of Venice Care Limited versus Cumbria County Council.
Yeah.
Paragraphs 25 and 26 of my skeleton. It's at tab 7 of the authorities bundle, although I don't intend to go beyond the extracts quoted in my skeleton. In brief, that concerned a TRO which restricted vehicular access to a narrow highway in Carlisle city centre. And it was made on safety grounds. It restricted vehicular access to one path and it made another part one way. And one of the challenges, as is reflected at paragraph 49 of the judgment, one of the arguments was, well, there's no evidence of the effectively pre-existing safety issues with this. The overarching point that comes from the case, and in particular perhaps paragraph 55 from the court, is the rejection of the proposition that in effect you needed to have detailed specific evidence to form a view that in that case restricting vehicular traffic on a narrow highway would achieve a safety purpose. It was recognising, as well as 56 goes on to note, local knowledge, etc., that there are some things that are obvious or self-evident and don't need to effectively have specialist expert analysis. That point is also reflected, well, I should say that Venice Care is not an outlier, but it's reflected in the approach the courts have consistently taken to these types of challenges. I also referenced the case of Better Streets for Kensington and Chelsea. That's found at tab 10. And that concerned a decision not to reinstate cycle lanes that had been, I think, put in during COVID. And if I may just take the court to the authorities bundle, because there are just two paragraphs which I've not extracted from surrounding the paragraphs I have quoted. I'm at page 268. And my apologies, my Lord Dove. Can I assist? I appreciate your authority.
Give me the paragraph of the judgment.
The paragraph is 86.
Thank you. No.
I'm grateful. And paragraph 86 notes effectively that this was in part an irrationality challenge, and the court makes the observation in that case that at the heart, the fact that this is a merits challenge becomes evidence at the point at which the claimants make it plain in their view the only rational decision the defendant could have taken was to install cycle lanes which have been removed. There are huge and I find insurmountable difficulties in making good this contention on the basis of irrationality. That is particularly so given we are here dealing with a democratically elected body. I just make the same observation in relation to this case and the appellant's stance, and that the appellant faces those same difficulties. 87, and this in part explains the judge below's reference to Tameside, given it is important to note, ground 5 as it was pleaded below raised that there was not sufficient evidence to come to conclusions. That's why Tameside is addressed. But notes again, where there's an attack, it will be in the whether the information was sufficient on an irrationality basis that comes from Tameside. Paragraph 89, just to note that again, the court, like in Venice Care, is highlighting the importance of local knowledge, and that the court can take into account local knowledge in relation to these matters. And finally, paragraph 90, my apologies, this wasn't sidebarred. But the point that in that case there was a recognition that there was limits to the available data, but it advised members that temporary cycle lanes have made cyclists feel safer and encouraged them to cycle or cycle more, consistent with the cycle code, nothing legally problematic. just recognising some points can be self-evident. You don't necessarily need evidence to say that a cycle lane will make cyclists feel safer. My learned friends already touched upon trail riders' fellowship, but just to note those observations quite well known from Longmore J in relation to this balancing exercise, which is at the heart of the challenge to ground 3. That's really the exercise that is being challenged. Noting that where that balancing exercise is carried out, that will be sufficient. It's not a particularly difficult or complicated exercise, and it's not difficult to imagine in that case that the Director of Transport would not be acutely aware of the obligations, as far as is practicable, to secure the expeditious, convenient and safe movement of traffic. My Lords, if I may at this point deal with and delve into, insofar as I have to, the 1996 regulations in relation to the RO. My Lords, the starting point is that the respondent's primary position is the question of into force, into operation, the language used, is not necessary to determine this appeal. There is, as your Lordships have noted, no challenge to the procedural requirements of the regulations being followed here. To confirm the respondent's stance to questions your Lordships asked my learned friend, there is no requirement for the order itself to set out a date when it comes into force. It is a procedural requirement as something that must be indicated on the notice of making. It therefore is not something that, as it were, necessarily, and I'll explain why I use that word, affects the validity of the order. It's a procedural requirement point as to publicity. If I may endorse your Lordship's view as to, in effect, the 3 stages.
Well, I changed from 3 to 2 at a later stage, and my views change by the minute. So don't assume that anything I've said, A, is what I actually think, or B, that I understand what I think, or C, that I'll think it tomorrow. So be careful.
Well, then let me not endorse anything your Lordship said, but just put forward respectfully.
I said at one stage, making, enforce, and criminal enforceability, and then I changed my mind.
No.
Yes.
So my Lord, I think let me answer this carefully. Mm-hmm. On the regulations, there are 2 stages, seemingly, or at least 2 terms are used. Well, actually, a 3rd term is used on commencement, but there's a making stage.
There's a making of the order stage.
Making of the order stage, and through publicity saying when that comes into force. Mm. And there is some validity in the bench's observations about, well, what does that mean in terms of whether it's enforce or enforceability? That partly explains why a number of local authorities use that phrase into operation when in relation to these orders.
So what do they mean when they say enforce operation? What did your clients mean?
So to answer your Lordship's question, it wasn't the intention of the Council by listing a date of the 24th of January. Sorry. I do just want, it will explain the terminology I was about to use. Can I just set out how in practice there are 3 stages or concepts that we say are important for this court? There is the making. There is the coming into force. And then there is the enforceability stage, or if I may use the term, when the order is effective. And the reason I use that term effective is because it was the wording of Lord Mingdale in the McLeod versus Hamilton case, which is then cited with approval in Heron, where Lord Mingdale says the order is not effective unless and until the Council complies with, back then, Regulation 15C and erects road signs at the locus. So then, my apologies, to go back to what did the council intend? It was not the council's intention for these TROs to become effective on the 25th or 4th of January, in a sense of road signs being erected, people being prosecuted, these restrictions having any practical effect. As I will return to in my submissions, your lordships have recognised, with the hard edge approach of the appellant, the very significant practical difficulties that come in saying that in bringing forward, I'll be careful with my language, in making a TRO, you have to, as it were, establish very clearly exactly when it's going to come into effect, because of difficulties with complex transport schemes, difficulties where, of course, if it's got a long construction period, you don't want it to come into effect when the construction period begins, but ends. How you square that. Just an example from very recently, in a matter I was dealing with, highway compulsory purchase orders. When going through the process of confirmation, the inspector will ask, well, have you got all the TROs in place before we consider confirming the order? And so I don't say those practical difficulties are the complete answer to this, but I do say they are very significant considerations for local authority decision making.
So you might argue as follows then. You've got to put the particulars in parts 1 and 3 of Schedule 1. That includes the date on which the order has come into force. You couldn't do that because you didn't have a clue when you get the money. So instead of saying when it comes into force, you chose a word that's possibly meaningless called operation. And if all things go pear-shaped, the money doesn't come, the TROs don't come, you will turn to 21B and say, well, we said operation, not in force, because we were unable to say when it would come into force, and we'll have to revoke it. Is that how you think it's going to work?
That is one option, yes, or we just revoke it. And my learned friend says, well, it's very difficult to progress another TRO to revoke a TRO. Not in reality.
So one option is this Rule 21B situation, and we don't have to decide this, you say. Operation was decidedly to avoid saying when it comes into force and to avoid giving the particulars. And you can revoke it that way, or you can change the date, or if that's wrong, you'll just have to revoke it.
Just revoke it. And I don't say there are huge difficulties. It's done all the time to revoke TROs.
And even if it is, it's your fault. You'll have to take the trouble to do it, you say.
Yes.
Yeah, so that's what you say would happen.
To definitively answer in two ways your lordship's question on, or the thought that follows, which is, does a failure to, as it were, follow these requirements, is it a breach of the requirements or is it an issue with the order? The failure to either indicate when an order comes into force or put out the signs before the date you've indicated does not nullify or negate the order itself. And I say that for two reasons. Firstly, in fact, the answer comes partly from Heron. And if I may take your lordships to page 106 of the authorities bundle, and my apologies, Lord Justice, it's paragraph 32 as well. I want to contextualise this point. Part of the argument of this case was failures to properly sign a controlled parking zone invalidated the entire controlled parking zone. That was under slightly different regulations, Regulation 4, but one of the reasons the court rejects that is by reference to this principle at paragraph 32, which would be the complete answer to my learned friend's point, which is Regulation 18 is interpreted as a duty. That even where a statute is clear in imposing a duty and does so in terms that are apparently mandatory, won't necessarily be interpreted as invalidating steps by a public authority not in strict conformity. we are aware of no authority, and we would rely on this principle to say, and this wasn't a pleaded point, but just that a failure to erect signs in line with Regulation 18, because if it has come into force in January of last year, wouldn't invalidate these TROs.
Or alternatively, a failure to identify the date on the notice of publication wouldn't mean that you couldn't subsequently erect the signs and prosecute people.
Yeah. And the second reason why we say that, and if I may just jump ahead to paragraph 35 and 36 of my skeleton.
Yeah.
Is it comes to the court's powers when they are considering a TRO challenge. Yes, oh sorry, it may assist the court actually to go to where it appears in the authorities bundle, which is authority bundle page 35, I think. Well, oh, sorry, 35 is the next paragraph, which, sorry, let me take it in stages. If I may take the court to authority bundle page 34. So a challenge, a statutory challenge, which is brought here, can be brought under one of two heads. Either that the TRO is not within the relevant powers, and that's been held to encapsulate public law elements, or that any of the relevant requirements have not been complied with. That's a procedural requirement challenge. Turning then to paragraph...
In relation to the order.
Yes, that the procedural requirements...
That order, and I thought you were about to argue the date was a procedural requirement of the notice to publish, or the publication of the notice of making.
I think what it's talking about, which is the procedural requirements that apply to the making of an order, which includes the publicity element that goes with it. And there is a cross-reference to relevant requirements being the procedural requirements in, that's it. Okay. My Lord, for the for your note, paragraph 34 2b notes that is a reference to the requirement of the regulations. Such things. So that's what it's talking about. It's the procedural requirement with the regulations. And the point is then, or the point where I've been leading to is at paragraph 36, which is if that challenge is brought, you have failed to identify the date in which these orders come into effect or enforce, you failed to put up the signs, then the question for the court, or the power of the court, under 36(1)b, is that, or that the interests of the applicant have been substantially prejudiced by failure to comply with any of the relevant requirements. So the point being, it wasn't clear, and this does provide the answer when I come to it under ground 1 and ground 2. The appellant hasn't pleaded a breach of these requirements. If the appellant had pleaded it, the question would be, well, what substantial prejudice has been caused? And that is where the fact that without signs, these orders are not effective, would provide, we say, the complete answer. The judge below did note that the appellant did not raise or argue any substantial prejudice being caused by this. All of that goes to show or confirm that these aren't errors with the order per se, and go to nullifying or making invalid. They're errors with the publicity elements. And while I appreciate the authorities are not before the court, in other instances where it's been a failure to hold an inquiry or things like that, the court has had regard to that question. Is there substantial prejudice?
Well, your point is that the procedural requirement to issue a notice with certain information identified within it is one of the relevant requirements and does not go to the power to make the order.
Yeah.
That's it, isn't it?
Yeah. On those points, and I have in part touched upon and already addressed some of these submissions. Turning then to the first ground. The the fundamental flaw, as I noted, is that the TROs have implemented the scheme. I think I have addressed already, unless the Lordship wish to hear further about the wording of the resolution. Might come back. And equally, I just make the point of paragraph 42, all those practical considerations that mean that it can't be said that the making of the TROs by themselves in isolation have implemented. And therefore, if the respondent is right on that, then ground one falls away. I will address it here, although in my written arguments I address it in more detail at ground two. Let me just be absolutely clear on and I'm at paragraph 43 of my skeleton. The response to this legal hook that making the orders have implemented the scheme because there is this requirement to put up certain all those numbers. The answer to that is no, because these orders are not effective until traffic signs have been erected. Once they are effective, maybe you could have an argument about whether they have implemented the scheme. But and this is the point the learned judge below addressed this point on. Without the signs, there is no argument that any driver in Harrogate would have no idea that there's just no evidence on the ground of these things, intentionally so. Nothing's been erected to bring them into effect. And so, it is with respect, I'd say, almost getting as high as a legal fiction to say that the schemes have somehow been implemented. And that also, given it clearly was not the respondent's intention, that in making the TROs but not bringing them into effect, the respondent has sleepwalked into implementing a scheme they don't have funding for. So,
I think if you look at the obligation regulation 18, that isn't concerned with deciding when the order comes into force. It imposes a duty to take steps as are necessary to secure before the order comes into force. So it's not a bringing into effect. It's a statutory duty. You could get a declaration or a mandatory order. You say it doesn't invalidate for the reasons you've given the making of the order itself. But it's not a provision that tells you when it comes into force. There's an interesting argument as to whether or not you could, in your publication notice, say the order should come into force when the signs are put up, or the order should come into force on the Director of Traffic publishing a notice in the Harrogate Mercury or whatever like that. But it's not really Regulation 18, is it?
no, but
Regulation 18 is a duty, and if anything, a protection from criminal enforcement.
that if you haven't properly signed these restrictions, then you can't. They don't have effect. You can't prosecute them.
Like those criminal provisions, you must get the consent of the DPP to prosecute for things like blasphemy. The law against blasphemy was gone now, I think, was in force, but it wasn't effective in that case because you hadn't got the consent. But that didn't mean the law wasn't there, as Miss Hutton's case. Yeah. And the problem may be that you haven't specified, unless in operation means in force, which you say it doesn't mean, you haven't specified when it's coming into force. But that's not the subject matter of this challenge.
And my lords, if I may, it's a point I've had to struggle with before in other cases about whether you can not put a specific date, say after this point when this happens. There is no authority on that. I'm sure many people would be grateful if the court, but it isn't necessary to determine this.
It would be obiter anyway, and it might be wrong. Yeah. Well, my colleagues wouldn't be wrong, but I might be wrong.
But that is touching upon some of the difficulties that have been faced in this regime.
Yeah.
I'm aware that the court wants to. And
that's your ground one anyway, though, isn't it?
It is. I have got submissions in writing, and I would want to have expanded them if necessary about why public engagement doesn't equate to consultation.
Yeah.
And I don't know whether the court wishes to hear them. Given
well, take us to your skeleton. If you've got them all there, unless there's things on top of the skeleton. Otherwise, if we come back tomorrow, we'll come back tomorrow. It's not a problem. You've both got to have a fair chance to put your client's case because it's important to both of you. I
will touch on it then just briefly. So, even if the scheme has been implemented, contrary to our primary submission.
Could you just remind me where you are on your scale?
My apologies, my lord. I'm at paragraph 46, because this is also criticism levelled at the judge.
Thank you.
Yeah.
And this is we say another flaw in the appellant's case. The term public engagement does not require formal consultation. I don't think there's any dispute on the principles that there is no general obligation to consult. You need to find a specific source.
Well, this isn't just consult, is it? This is reconsult.
Sorry, my lord. Yes.
As to which there is a separate line of authorities recently endorsed in the Court of Appeal about how one should approach the question of reconsultation. So that's an additional overlay, but that's not your point here. The point here is what was meant by public engagement.
Yes, because the source by which, because there's no general obligation, you need to either point it fairness or something like that. The source in which the appellant, has always put it is they hang their hat on the wording in the resolution of public engagement, and that equals public consultation. Did the council, therefore, does the reasonable reader read it that the council intended for there to be a fourth round of formal consultation? And just briefly, no. Public engagement outcome in the words used does not mean public consultation. The distinction between consultation and engagement is made clear not only from, as it were, the words themselves used in the resolution, but also from the officer report at paragraph 5.1, 5.2. Your lordships have been taken to 5.2. I also wish to go to 5.1.
Yep.
And just on language, does the author of this resolution, the people who made it, view there to be a distinction between engagement and consultation? Yes. At 5.1, it's noted in the first sentence that officers continue to engage and consult with DFT and WICA, i.e. the author of this report, the author of the resolution, is in that sense not viewing them to be one and the same. And that distinction is then reflected in 5.2, given that it's a period of public engagement as well as any TRO public consultation. So again, a distinction. If the consultation is being used there in terms of formal consultation, if the authors wanted, in effect, a formal non-statutory consultation, they could have easily said so. They're using a different term of public engagement.
Yeah.
That's also an answer to the submission, the fourth submission, that there's a legitimate expectation.
Well, also, a period of public engagement is proposed to understand the levels of public support. Now, I understand Ms. Hutton's submission that you can't understand the level of public support unless they tell all about it and give their views and so on. But you might want to submit that a period of public engagement to understand the level of public support is just saying, look, we've changed this, we're going to have a bus lane and a cycle lane. Are you happy with that?
And I don't...
It all depends.
And because I don't think it's necessary to get to the fourth point, which is if there was this requirement, then we have done it. But Mr. Roberts' witness statement sets out how the website was kept updated with these details the public could access, the meetings with various forums, going down the road and meeting with retailers to understand the impact to them, these things being reported back to the ACC.
Well, that's another thing. It's odd if you're relying on 5.2, you don't want to report it to the ACC. You want to report it to the council if it is a consultation requirement.
Yes. So we say even if this scheme has somehow been implemented and required public engagement before, then we've met that requirement. If I may just explain, and I appreciate this probably might not be critical, but if I may just explain one criticism made of the judge, and just to explain it, I'm at paragraph 47 of my skeleton.
Yeah.
Because it was repeated orally. A criticism was made of the judge the judge below making the point that if there was a concern about a failure to consult, that should have been brought to the November resolution. Just to explain what the judge is saying on the basis that the resolution properly interpreted required public engagement but not consultation, the judge's point is, if you wanted consultation, then you should have challenged at that point in time because consultation wasn't part of the preconditions or roadmaps to implement it.
Oh, I see. Right.
That's
Yeah.
the judge's point.
Yeah. Okay.
And we say that's a valid one. I think the remaining points under ground one I can leave on my written argument unless
Yep.
it will assist the court further.
No, because you say legitimate expectation follows.
No,
If it means what it says, Miss Hutton means, then there's no legitimate expectation. If it does, it doesn't matter how you label it. They were promised it and they didn't get it.
There's no clear, unambiguous to meet that high standard set out in, I think, Bancoat.
Yeah. So ground two then.
Ground two. Firstly, I note, and I will not repeat, but I note ground two is predicated on the TROs implementing part of the scheme, and we say that they've not done so. The council is not irrevocably committed with TROs 1 to 4 for actually then doing this if funding doesn't come forward, if TRO 5 weren't to be granted, all of those elements. There's the roadmaps your lordship has noted the council could do. But to address the detail of the criticism, which is it was fundamentally irrational. Sorry, no, before I do that, if I may just highlight and reinforce the point at paragraph 54, which is the overarching point, which is, and I think this point was referenced in the morning, it can't be said as a generality that the respondent acted irrationally in securing the necessary legal orders to deliver elements of the scheme before the funding was accepted and the scheme was implemented. They had to do that for a whole variety of reasons. And we do endorse the judge's observation at paragraph 36 of the High Court judgment that there can't be anything remotely irrational in preparing for the implementation of a scheme bit by bit with the intention of arriving at a point where it's ready to be brought into force as a whole. It comes partly back to the difficulties in decision making as to how local authorities can deliver these larger scale highway transport schemes. In effect, I think the appellant stance is we had to get everything else in a row first, and then the TROs are the last thing in the process. There are a lot of issues with that, including the need for TROs to be in place to provide reassurance to the funder that they're not going to give funding and then be bogged down in a challenge for a year and a half that might prevent the scheme coming forward. But there is, it's fair to say, and I want to address it properly and fairly, a specific criticism, which is that in effect making 4 TROs without the 5th is per se irrational. And the respondent would submit it is not for a number of reasons. Primarily, it is important to understand the nature of the decision that was made. It is right to say that TROs 1 to 4 were the ones that were made without modification. And I'm at paragraph 57 of my skeleton. But it is wrong to say that in effect there was no decision made in relation to TRO 5. That criticism would be entirely valid in relation to TRO 6 that was abandoned. And
Well, there was a decision made in relation to TR6, but it was to abandon it.
To abandon it. To avoid. But TRO 5 was considered in the report. It was, and I can take your lordships to where it is, but perhaps for a moment I'll deal with that under ground 3. It was considered whether it met a purpose, a qualifying purpose. It was considered whether it would be expedient to make it, and it was considered whether it, in making it, it would accord with the 122 and the section 14 duties. The decision was, though, and taking a step back and looking at it, concerns were raised in relation to TRO 5 in the consultation. And so the respondent, acting reasonably, listened to those concerns and sought to modify it and rely on the procedure under Regulation 14 to modify it and then come back. My learned friend talks about fettering discretion and those elements, but the way I put it in skeleton, I think I endorse orally, is the decision was made to progress TRO 5 positively forward with the intention of making it. I don't view that as fettering a discretion, but I view that as consideration of its benefit. And anyway, that would be a challenge, actually, in relation to TRO 5.
Well, yes, they'd be able to say they fettered it.
Yes.
It was already, the pass had been sold. They were
Yes.
bound to make it.
Yes.
But it wouldn't look good for TR 1 to 4. But what you say is they had a reasonable prospect that it would come through, and that made it not irrational.
Yes. And again, the harm that is said is a theoretical one, that effectively if TRO 5 weren't to happen, this council, without funding, etc., would prevent to paint a bus lane where there are parking spaces and do all these things. But that's and the High Court judge below recognised this. That there's never been any intention, evidenced, inferred, etc., for this authority to, as it were, partially deliver on relation to TRO 1 to 4. The intention is clearly to prepare bit by bit for the full implementation of the scheme. What happens if it fails, or fails for other reasons? No evidence of partial scheme comes forward. Those TROs get revoked. I just wish to phrase it in this manner. The question is not for this court, could the respondent have decided to wait and do them all together? Even frankly, the question isn't should the respondent. The question is whether it was irrational for the respondent to do so. And in the context of the decision making that was made and clearly articulated and understood, it can't be said to be irrational. And that is also a complete answer, and I deal with it in detail in writing, so I might not deal with it too heavily orally, in relation to reliance on the cycle lane when talking about the benefits. Well, that's because it considered TRO 5, it looked at it. And that's where there was a reference to the cycle lane in the expediency consideration. But it's not right to say there were no benefits to cyclists from TRO 1 to 4, if the point is put that way. They were going to be separated from general traffic by being able to use the bus lane, which, as I'll come on to, and in fact was recognised despite quality assurance panels as that was a safety benefit in doing so. So there were 3 points put underground to the enforce point, which I've addressed, the timing point on 4 versus 5, which I've addressed, and the benefit point. My lord, if I may just pick up on one point, which is the lack of a senior courts at discretion point.
Yes, that is my fault. I forgot this was statutory. You'd say it would be the same for the inevitability.
It's a simplex point.
Well, it's a simplex point. Also, the wording specifically of paragraph 36.
Substantial prejudice.
No, it's simply that paragraph 36. Sorry, when I say paragraph 36, I mean paragraph 36, the road traffic regulation.
Yeah.
It says that if it's satisfied that the order is not within the relevant powers, may quash, not must quash. And so that point would go to the consideration and discretion of the court in whether to quash the TROs. And we ask that judicial notice is taken insofar.
Yeah.
If I may just take a sip of water before...
No, we're making you go at a pace. Just think when that cycling lane is there, you'll be up and down it like a yo-yo, so... If it's ever there. Round 3, you want to go through in detail on the documents.
I do.
We understand the arguments, so do take time to take us through what you say is the answer to the case that Ms Hutton has put on the 4 areas.
Yes.
I forget what they are: congestion, safety, climate change, and something else.
Yes.
And that's really by reference to the documents is the most helpful way forward.
Yes,
Yeah.
and my lord, that's what I plan to do.
Yeah.
If I may start with highway safety. So I set out the context in round 3 between paragraph 74 to 80, just making that observation I made at the start, which is we will look narrowly, we will go into the detail, but we shouldn't be lost sight of what the overall balancing exercise is.
Yeah.
The overarching submission when I go to each of these documents will be as the judge found. The arguments are based on misreadings, misconceptions, or partially applying elements that might apply to the scheme, but not to the TROs. Starting with safety. And I'm at paragraph 81 in my skeleton. The first point is that safety was considered in the officer report, and in particular, the safety benefits that come from separating cyclists from other traffic. I want to make sure that is referenced at numerous places, but supplementary bundle page 151, it is noted as a benefit under supplementary bundle page 151 in the report, paragraph 1 under the draft bus lane. This will separate buses and cyclists from general traffic, reducing the likelihood of conflicts with other traffic. And we do say you don't need technical evidence for that proposition. That is self-evident.
Yeah.
Really, the criticism comes from two documents, or reliance comes from two documents, the road safety audit and the quality assurance report.
Yeah.
In relation to the road safety audit, to which less time was spent orally by my learned friend, but let me address it. Important to recognise the role of it, which is to raise and identify problems to be addressed in the detailed evolving design of the scheme. It's an iterative process of improvement, and the document was dated in July 2024, and none of those iterative concerns and improvements made the scheme unsafe, which is what the appellant would have to show. And the reason I can say that, and I'm not giving evidence here, it is addressed expressly in the officer report, and it is at so the officer report takes the approach which I think is helpful, but some of the details in the main body of the report, a lot of detail comes from the detailed responses to the objections.
Yeah.
So they do have to be read together, and the judge below read them together. Supplementary bundle page 215. Just to show that this was something that was aware of. Supplementary bundle page 215. It is noted there at the bottom. A road safety audit has been undertaken for the scheme and any safety concerns addressed. So the point is that this was something that was aware. This was something that is touched upon in the report. These were issues that were addressed, none of which made the scheme unsafe.
Well, what is said against you is that they didn't specifically refer to either of the two documents, and one refers to it as a critical concern, and I forget what the other one refers to it as. And it said those were not referred to, and they were a mandatory material consideration, and the absence of any reference to that is misleading. Ms. Hutton says if you read safety concerns addressed, nobody would know that there's a critical concern outstanding. That's what she says.
So this is the response to the road safety audit, and that's that. Let me deal with the quality assurance report, which is where the critical concern comes from, and explain that.
And that's the WSP document, is it?
Yes. Let me find my hard. Sorry, my hard copy
It's
is.
it's
It's
this
144, actually.
Yes, it is.
In large print for the
Yeah, no,
elderly among us. You don't need the large print.
I've rather
lost
lost my large print copy that was made over the lunch. Well, perhaps I can do it by zooming in on my digital copy, actually. So two responses to this. Firstly, it is important to understand actually what it is saying. It is not saying that the scheme or the TROs are unsafe. In fact, in that summary of quality review panel box, it is expressly saying that the scheme will introduce enhancement for pedestrians, cyclists and bus users with improvements in terms of safety, ease of moving through the area and general experience for walking and moving.
Where are you reading?
My apologies, my lord. In the summary of quality panel review box, turning the page over, the second last paragraph in that box, on the page 2 paragraphs above quality panel board meeting outcome.
Okay, schemes.
As such, it is acknowledged.
Yes.
Oh, I've got it, yes. So it's better, but it could be better still.
Yeah, and what does unresolved critical issue mean? Well, to take it in short terms, this is actually reflected in the text below. This issue was raised by the Quality Panel Board.
Who are they?
I think they're Wyker and Active Travel England.
So they're not your client?
No.
So this is an external document?
Yes.
And when was your client provided with it?
So I think the...
It's dated the 6th of December.
Yes, it is dated the 6th of December. So, but in fairness, in terms of it comes out of, and the response I'm about to give comes out of earlier meetings officers had with them. Because what's very important to understand about the reference to critical issue is, in this iterative process, originally they raised a lot of concerns and they discussed them through with officers. The point is, and it's slightly unclear from how it's worded, it becomes clearer if the rest of the page is raised, they raised this critical issue and officers disagreed with them about it. And the disagreement is really summarised on this page, where there's a paragraph at the bottom of the first page that says critical issue that outlines it. And it says, it summarises what it thinks the critical issue is, that effectively cyclist movements should be separated in time and space. This is then noting the detailed position of officers from the council. This was not possible for a range of reasons, but primarily because of the detrimental effect this would have on bus journey times and constraints presented by limited carriageway width. It should be noted introduction of straight on and left turn would offer greater protection as would have otherwise been, i.e. without this, if we're doing nothing, would have otherwise been mixing with traffic in the right lane.
Well, I'm just not with you.
I'm sorry,
I'm sorry.
I'm
trying to find this. Start again. Page 1 is not on page 1. Page 2, am I looking at page 2?
Bottom of page 1 at the bottom, I think, is where you're
Well, there's
referring
a box,
to.
but what
Critical
you just
issue.
read...
Sorry, the last...
Start the paragraph critical issue.
I don't have a paragraph critical issue.
No.
I'm sorry to say. This document, is it?
It's the one we got.
Oh, yes, the one I've got has got those words blanked out.
Redacted.
The critical words are blank.
Let me make sure.
One thing they taught us in judging school was how to read. So I was beginning to worry. Don't worry, Mr. Smith, I'll get there in the end. Just every case is one document that's fated in terms of size and things being cut out. Thank you very much.
My apologies, my lord. For me, both one thing you're taught at barrister school is to watch the judge, and I wasn't watching, my lord, so my apologies. On this first page, this summary of the quality review panel, it's noting the critical issue, and you were taken to this.
Yeah.
And the first line is effectively noting what it said the critical issue is, that it's not separating out cycle movements in time and space. It goes on to say this was not possible, and just pausing there, this is because this issue was raised with officers who gave their detailed response. I'll go to
So
that
just
in a
pause a
moment.
moment. Sorry, I just don't see this.
It's on here, let me go.
Sorry.
So he's
On the
He's
first page.
here.
Oh, right, you're on the first page.
Yes.
I did ask, I said it's not on the first page, it's the second. But you're at the bottom of the first page,
That's it.
okay.
Yeah.
Right, okay. And now I'm finally with you. Because the same words in different form come over the page as well. I'm now with you, thank you. Sorry.
So it's noting this issue,
Yeah.
but then it's saying this was not possible, as in we're
Yeah.
addressing it. And this has come out of a detailed meeting with officers where the panel raised this concern, and they will explain why it wouldn't work. Primarily because of the detrimental effect this would have on bus journey times and the constraints presented by the limited carriageway width. It should be noted the introduction of a straight on and left turn in the left lane was introduced to offer greater protection for cyclists who would otherwise have been mixing with traffic in the right lane. between the critical width. The simple point, or sorry, probably not simple. The point being, this was a point expressly raised and expressly responded to by officers who were not concerned about it making the scheme unsafe, and nor were the panel. That's answer one. Answer two, and this, if I may, shows the robustness of the decision making. This point was expressly raised in the officer report and responded to.
Where's that?
If I may take the court to 198 of the.
Yeah.
Is it 198? Okay, sorry, it's 196. Where, and I can't quite understand how this is happening, but an objector is effectively aware of this critical issue. I'm at paragraph 2 on 196 as a comment received, is aware of this critical issue and raising that the council aren't doing anything about it as a concern.
So where I'm now lost.
My apologies, my lord.
Page 196.
196.
The second paragraph.
Second paragraph.
I believe that the removal of the disabled parking bays.
No, sorry, supplementary bundle page 196, early release.
I think number paragraph 2.
Numbered paragraph 2. Yeah. The grounds for my objections are refusal by the council to introduce early release for people on bikes.
Yeah.
Is that it?
This is that point.
Okay.
And aware, because details of this meeting were publicised, or aware that the council were refusing to do this.
Right.
And the point is, in the right-hand column, officers give their detailed response as to why they don't think it's appropriate.
Right. Okay. So safety we've dealt with.
That's it.
It's dealt with in the document. It's dealt with in the report. So what's the next one
Yes.
you want to deal with?
The next one is journey times.
Bus journeys or general journeys?
Well, I think they can be dealt with together, but I'll deal with them separately.
Okay. Journey times. Yeah.
In terms of journey times, in terms of, let me start with bus journey times, and to go back to where it's dealt with in the report at supplementary bundle page 151.
Yeah.
Important to read it in full. The benefits of bus journey times are referenced as being that it will improve. I'm at paragraph 1. It's also at paragraph 2. It will also improve journey times for buses travelling to the bus station. So the benefit is put as buses travelling to the bus station, and the reason for that is because a bus lane is being provided to the entrance of it. That is self-evident.
Yeah.
That providing a bus lane to the entrance of a bus station would provide benefits in that way. Nowhere, and this is where we get the crossover, if I may, into bus times generally and also general congestion, because the points sort of overlap and they go to the same modelling. Nowhere does this report say or mislead that it will immediately, as it were, address or reduce general vehicular congestion in the town centre. Instead, it's the opposite. It expressly talks about rebalancing. The whole purpose of this scheme is to rebalance away from the private car and to promote, I think what was referred to as slow travel or active
Slow
travel.
modes.
Slow modes. But of course, the short-term effect of doing that is turning a two-way road into a one-way road, which self-evidently could have an impact. So there was no, as it were, suggestion or misleading point that this would, as it were, address congestion or wouldn't potentially have some congestion impacts. In fact, in the comments to the report, congestion in this point is dealt with in a number of ways. If I may firstly go to 198.
Yeah.
CV 198 and consultation or response 5, which is raising a concern that effectively the one-way street will cause vehicles to go through other
We
roads.
really can't spend hours going through every detailed point. You need the bullet points, really.
My apologies, my lord.
Yeah.
The bullet points perhaps are this. I'll jump straight to the modelling and why
Yeah.
the modelling didn't have to effectively
Yeah.
be expressly referenced in this. The modelling is a number of points on the modelling. 82 is my starting point. Supplementary bundle page
Yeah.
82. Only 2 sites examined. Site 1 is where the bus lane ends. Site 4 is further south. Headline point 1. Site 1, the entrance into the bus station is found to be improved.
Right.
So-
Just show us the piece of paper where it says that, because we really can't spend many hours looking through every line for every metre. So where do you want to go to get the view that site 1 it was improved?
8.1.9.
Okay, I've got that. So that's page 115, 8.1.9. Yeah.
Yeah.
Site 4.
So site 1 is the entrance of the bus station, shows improvements in all metrics. So it's not inconsistent with what is said in the report, which is it will improve journey times into the bus station.
Yeah. Site 4 it says it's worse.
Site 4, it says it is worse, but it says there are 3 points, 3 responses to this. Firstly, it says it's not unexpected, given exactly the point, which is the rebalancing. Secondly, it says that it will continue to operate within capacity, and the paragraph below says it will not have a significant impact on general traffic. In fact, it's showing it's a matter of seconds. And thirdly, and I appreciate this is a detail point, but I do say it is an important one, the reason for those disbenefits to Site 4 was not relating to the TROs.
Well, you would make that good, but
Yeah.
really, there's got to be a sense of proportion about this. Why not?
Because, and my lord, if I may just give you the reference, let me make sure I've got the correct reference. Yes. 6.2.5 explains what is causing the increase, and it's that more road space and cycle time is dedicated to active travel. That's 6.2.5.
Yeah.
Cycle time relates to traffic lights. That's not
So
TRA.
6.2.5.
Yeah, page 108.
Yeah. There's an increase of queue length which may affect the start. PRC, whatever that is reduced. However, the junction of the scheme remains within capacity. Yeah.
The DOS and total delay show an increase as more road space and cycle time is dedicated to active travel.
Yeah. So there's more cycles, more space for cycles, less space for cars, and there'll be congestion because of that.
Sorry, cycle time confusion there means the time in which it's
Yeah,
green.
but the
yellow.
cycle time's affected because they've adjusted in the model the sequencing of the lights to allow active travellers, i.e. cyclists,
Yes.
to have more green
Yes.
time.
Yes, but that's a scheme. That's not to do with the TRO.
Yes.
Yes, and equally more road space is because an island is being removed.
Yeah. What's your next point then? We can't get into this level. It's absurd, Mr. We're not a travel committee, and it doesn't read out from the page. We need lots more evidence about this travel island that just emerged. So we've done congestion. What's your next point? Is it climate change?
My next point is climate change.
Yeah.
And the I'm just checking my notes, Jack. I appreciate we need to move on. That I've just not missed in my rush any point that I wanted to raise, which isn't to do with data or things like that. But no, the overarching point is this modelling data was not an obviously material consideration in relation to the TROs. And nothing was inconsistent or misleading about the way the report put, which was that buses into the station would be benefited.
Yep. All I've got is disbenefit to general traffic. I've heard all the words you've said. With the greatest of respect, they've meant nothing to me. That's the impression I've got, is that there's a disbenefit to general traffic, but when I read the things as a whole, it's not that significant and everything works within scenarios. I don't think this court can be expected to go further and decide whether it's the emergence of a traffic island or whether it's the resynchronization of the green lights on traffic, unless you can take it very, very quickly.
No, look,
Something that shows that disbenefits is different. You're not going to help us, I'm afraid.
Okay, the one sentence I would say is those general traffic disbenefits are not associated with the TRO.
Yeah, and where do you get that from? You see, I don't see that on the words in 625 without massive explanation and understanding. The words of 625 are virtually meaningless to anyone who's not a transport expert. And all it says is more road space and cycle time is dedicated to active travel. That means to me that they're going to have less space for cars, more space for cyclists, or something like that. And that's going to cause more problems and disbenefits to vehicular traffic. And that's inherent in the scheme.
Inherent in the scheme, but not in the TROs, which are concerning just with a one-way, a bus lane. So that's the point.
Okay.
But let me put it this way then, and then I will move on, my lord. Even if I'm wrong about that,
Yeah.
and that this modelling was showing there is a general disbenefit to traffic arising out of the TROs, it wasn't significant. The junctions remained in capacity. It wasn't inconsistent with anything said in the report, which expressly talked about rebalancing the network away from private cars.
Is this in your skeleton by chance?
It is.
Yeah, take us to the paragraph of the skeleton then.
83.
You got that. At that point, even I understood about the buses going to the station, yeah. In fact, yes, well, that's exactly what I just said, isn't it?
Yeah. No, I'm just wanted to draw
It is the TRO. Because there's a bus lane, not a lane, not a car lane, there would be twice as many cars, less the ones that have switched to bicycles, in one lane instead of two. Yeah. Okay, that seems to me to be the TRO, but you say it's not, and I'll have to think about that. Climate change.
Of course. So the central allegation that is put in relation to climate change is that the decision maker was misled by them not being aware of, as it were, the mathematics in relation to the climate report from WSP.
The end result is that there'll be more emissions, not less, because of construction, and the figures that we looked at this morning show that, in a way that I didn't understand this morning, still don't understand this afternoon, that what you'll save from less car use is still less than what was there before.
Yeah, and
so that's what you need to address.
Yes, and the start point and end point of this is the fair manner in which the report dealt with this point,
yeah.
Which is at supplementary bundle page 153.
Yeah, I'm on that.
And 11.1.
Yeah, I'm on that.
Where it is noting this exact point. So that a further assessment is being prepared for the D-scape project that will encompass the public realm and require for funding purposes. Just to pause there on timing. It's right that the TROs were issued on the 10th of January, but this decision is the 13th of December. That's why, in effect, it's referring to the assessment not being complete, because the assessment was published on the 13th of December as well. So that's why there is reference here. Members are being made aware expressly that there is a further assessment that's being prepared. So that's not misleading in that way. But critically, the headline point that assessment for the wider scheme would show is expressly told to members in this paragraph.
Yeah.
As with all highway projects, the embodied carbon derives an overall negative impact. However, in this case, the Council is seeking to offset that impact by encouraging a shift to more sustainable modes. I think part of my learner friend's case is that offset is said to be outweighed. But that's not what the report is saying. It's saying there will be this overall negative impact, but that will be offset by, offset by the active travel that the scheme is promoting.
But what Ms Hutton says, if we go back to the document that you looked at this morning, it doesn't work.
But
and they weren't told that. It's a simple point.
But then I will go to that document and say that's not.
I think we need to go to that document.
Yes, of course.
It's 129.
Or 131 is the.
Yeah.
131 is the conclusion of that document. which is, and if I may just ask your lordship your lords to have, where I've extracted the relevant conclusion at paragraph 84 of my skeleton and compare the two, they are entirely consistent, which is that the conclusion of the report is that there will be an overall net impact, and that is not outweighed by savings from shifting private car use to more sustainable travel modes, leading to an adverse overall impact. That's that first paragraph under net impact on 131, but that's also said, that is also reflected in what the executive were told at this paragraph. There will be an overall negative impact, but they're seeking to offset it.
So not to mitigate it, rather than obliterate it or
not to outweigh
overcome it.
Or I see the language used, not to outweigh it, but to offset it and seek to offset it.
Yeah.
It then goes on to say, and this is the critical point, that the adverse carbon impact is justified as it accomplishes the vision for the development. It's also perhaps the last sentence. However, by enhancing sustainable transport options, the scheme aligns with necessary strategic outcomes to achieve decarbonisation pathways in the transport sector moving forward. So it is saying that mathematical impact is justified by the aspirations and purposes of the scheme. And that is reflected as well entirely. There's no misleading. That is reflected as well in what the executive were told in the officer report.
Right, and what is the fourth thing?
My apologies, my lord. Can I just make one final observation on that? I do say it is relevant by my third fundamental flaw. That is a carbon assessment of the entire scheme. This decision had a specific assessment of the TROs attached to it, and that it was appropriate for the assessment in paragraph 11 and that specific climate impact assessment as appended to the officer report.
Okay. And
So,
the fourth thing then?
Comparing apples and pears.
Yeah.
No, I think
I thought Miss Hutton had four things.
I've dealt with bus journey times and
and congestion generally. Bus journeys better into the station.
into the station.
And and times generally we've gone through. Yeah.
Oh, sorry. There was one point on bus journey times to explain a reference that the court's been given a few times.
There's a delay at peak hours, but out of side peak hours, it's all right.
Well, yes, that paragraph, but where that paragraph talks about, at one. Just to put it in, yes, 259 of the supplementary bundle.
Yeah,
where,
and there already.
Yes,
at
yeah.
12.
When it talks about neutral impact or quantifying, this is an extract from a financial economic assessment giving an economic value to elements of the business case. So therefore, when it talks about no benefits or disbenefits have been quantified and things like that, it's talking about putting a pounds and pence in a formula they're applying. So I just want, that's that context for that extract.
Attributing a financial value for
Yes.
their purposes, yes.
Yes.
They weren't doing the traffic case, if you like, yes. They're doing the business case.
Yes.
Right.
My lords, I've not dealt with in detail how the judge deals with these points. I deal with them in writing. Can I just make one?
Yes, go on.
Point, which is I think the submission is put that the judge made a mistake because he thought this evidence was before the committee.
Yeah.
He didn't make that mistake. How he addresses it, I'm at paragraph 66 of the judgment.
Yeah.
So he's gone through Tameside because the primary way the point was put, there wasn't sufficient evidence. He runs through at a bit more pace, but he runs through the other points. He notes, similar observations apply to the applicant's assertions that material matters were not taken into account or objections ignored. And this is the point where we dealt, that's where he's dealing with the point about whether effectively these evidence bases, these material matters were not before the executive.
Yeah. Okay.
So he didn't make that mistake. He does engage at that point. My lords, if I may, then just incredibly briefly, I've, as promised, attempted to assist by going through the documents in detail, take the step back and say that ground 3 is a challenge, an irrationality challenge, to the 1-2 balancing and the expediency consideration. And it is important, therefore, while we have given a clear response on those points, to return back to the guidance provided in Trail Riders Fellowship, which is that in considering whether the 1-2 balance has been carried out, it's not complicated, it's not particularly difficult, and where a report expressly turns its mind to the balancing exercise, which this report does expressly and clearly, that will be sufficient. The appellant's submissions are seeking to turn that exercise into something which is difficult and complicated. This fundamentally was putting in place TROs to provide a bus lane and one-way traffic that would help buses get to the station and protect cyclists by discounting them, separating them out. It didn't have to be a complicated exercise in going through and running through evidence to back up every proposition and point. And we would ask, with respect to the court, to bear in mind the point Mr. Justice Fordham said and Hawes, but many others have said, that this is an evaluative judgment, and those choices are entrusted to frontline public authorities to which there's latitude for judgment and appreciation. In this case, expert officers, well aware of all these points, they're touched upon in the report and in responses to the consultees, gave a clear and reasoned recommendation for making these TROs and carried out that exercise. And it cannot be said to be irrational, and it addressed and took account of all those points insofar as it needed to. I appreciate, and my apologies for doing so, that was a canter through ground.
It was a canter through, but it was very helpful because we've got what is the key things, because you can't expect a court to go through each and every line of each and every report with those things. It's a 1 day, at most 2 day case, but you've dealt with everything, so don't feel troubled. We've got a detailed note of everything you've been saying on grounds.
I'm grateful, but just before I sit down, first of all, can I just turn my back and
just double check that you've got everything.
And just to make that observation, which is, it is not the court's role to go back through and evaluate all these points. Yeah, it is a supervisory.
Oddly enough, we're familiar with that. Yes.
I'm very grateful, my lord.
Right, thank you very, very much. You've been very patient and very helpful. Right, Miss Hutton.
My lord, thank you.
Anything in reply?
Yes, my lord. Some initial points with regards to the resolution and paragraph 4.15 of the report.
Yeah.
My lord, that's page 9 of the supplementary bundle.
Yeah.
My lord, Justice Zacaroli highlighted 4.15 on page 9.
Yeah.
The issue of the possibility of the southbound.
Yeah, and your further submission on that is?
If one looks at the top of 4.15, elements that might be included.
Well, you've made that point a number of times. So, we haven't forgotten it.
My lord, but it's the point that, in fact, the possibility applies to all of those points and goes to the lack of certainty.
Yes, we've got that point.
My lord, if the resolution had been delivery as opposed to implementation, my lord, that wouldn't change my case at all. Because in my submission, the TROs do, as a matter of law,
deliver, implement, bring about.
Bring about. So if it had said implement, delivery would make no difference. My lord, there was an exchange between my lord, Lord Justice Lewis and my learned friend about the use of the word into operation. And could it be said, well, this has been deliberately used so the council could use Regulation 21 and revoke the order? My lord, if that's the impression the court gets, the appellant would be very concerned. No,
I didn't mean it in that way. No. When you come to analyse it, what I was saying was they couldn't give an exact date because they didn't know. So they picked a date and called it operation. And when you try and unpick what that means, one possible analysis, but it's not for this court by the looks of it, would be to say, well, that meant they couldn't do what was necessary, so you could revoke it. The other alternative is that it would be have to be revoked by a TRO. Your submission is no, it can't have intended that. Why on earth would they have made things which might have to be undone at great complication?
My Lord,
we have the submissions, yes.
Yes, my Lord. And just to highlight that at paragraph 18 of Mullane and Friends' first argument to the High Court, it is stated it's correct the orders came into force on that date.
Yes, that's,
So,
we know that.
so-
Yes, and
so
is
my
that
Lord-
right or wrong? Yes.
yes, so in my submission, there was a number of submissions on the need of the substantial prejudice point. But of course, in my submission, that doesn't arise, because my case is that these orders have been validly made. They have, in terms of the procedural points, they have the date on them that they come into force. Okay, use the word operation, but they have met the procedural requirements, and they are in force. This challenge concerns whether they're within the power of the Act. So the requirement for substantial prejudice doesn't arise. So my case is that those procedural requirements have been carried out.
I thought Mr. Riley-Smith said it still says may quash.
It still says may squash, and I'll come on to discretion in a moment, but it was the need to provide substantial prejudice. That doesn't apply where the challenge is based on the decision not being within the power of the Act. In terms of the practical difficulties, my Lord, I don't accept that there are practical difficulties. You have my submission on that.
Practical difficulties with what? Oh,
with making the orders.
Yeah.
You've got the 2 years, my Lord. And if your Lordships decide that I'm wrong and the date that can be inserted when making the order can be by reference to a future event, well, then that would deal with the point. Here, it doesn't arise. And I don't consider the court needs to address that. It needs to determine that issue because the orders had the date.
They've got a date in it, yeah.
Yeah. My Lord, ground 1 on consultation, my learned friend asked, well, why would you enter into public engagement prior to making the TROs? Well, my Lord, if the whole purpose is to understand the public level of public support of the scheme, of course you would do that. And in fact, it would be very strange to do it the other way around. I go through the whole process of making the orders without having understood what the public's view is. And my Lord, just to stress that the resolution has to be read with 5.2. And we know that the implementation, the delivery of the scheme was contingent on a satisfactory public outcome, public engagement outcome. My Lord, on ground 2, my learned friend says, well, there was intention to make TRO 5. Okay, it wasn't made, but there was an intention to make it. And in my submission, it's not enough that there was a reasonable prospect that it would be made because of the legal effects of TROs 1 to 4. It had to be certain.
Why did you say that there?
Because my Lord, goes back to this point that TROs 1 to 4 have been made or enforced. There's no discretion as to whether the sign should be put out. TRO, but because they couldn't in fact practically operate without TRO 5, it was irrational to make them separately.
They could
Unless
never
without
do it.
certainty.
It may be rational to say, well, we won't take a punt, but it may be rational to think, well, this is such a small change, it's unlikely to create problems, let's go ahead.
Well, my Lord, it was...
Irrational is quite a high bar.
Well, yes, my Lord, but if you're making orders which then require you to put out traffic signs and bring them to fruition without certainty that the scheme is coming forward, and one of the reasons for that is that you're lacking TRO 5, which is required, then in my submission it's irrational because you can't better your discretion on the consideration of TRO 5.
Well, everyone accepts that, and if it goes wrong and they don't make TR5, then they're going to be in difficulty. But is it irrational to take an educated guess is the question?
Well, in my submission, yes.
Yes, okay. That's
On the
ground 2
simplex,
then.
on simplex, just on ground 2.
Yeah, may quash, yeah.
May quash. My Lord, this is an appeal against the decision of the lower court, and the judge did not reach the view that in any event relief should be withheld as a matter of discretion. As I say, it's not been raised by my learned friend in a...
No, I see. It's a fair point if it's not section 31 to a...
Yes, my Lord. But even if it was open to this court to say, ask of its own motion would the decision have been the same, which is the simplex test, then it's clear it would not have been.
Well, the answer is yes, it would be if TR5 had been passed.
Well, but the error was not passing TRO5. The error was making TROs 1 to 4 without TRO5. So if we think of what practically would have happened, is TROs 1 to 4 would not have been made. It would all have been put off to another day so that they could all be considered in the round.
But if we know where we are now,
yes, my lord.
did Parliament intend us to quash things because of that?
Well,
It was Parliament saying, no, they've got to get it absolutely right. They've got to not make an order. They've got to be certain. Doesn't matter that, in fact, they were lucky, was made. Doesn't matter that everything that they expected to happen has come to pass. You must quash it.
But, well, may I just deal with what the practical effect would be? If this court accepts it's irrational to make TROs 1 to 4, because TRO 5 was in place, the decision, the alternative universe is not that they all would have been made together as at 10th of January. What would have happened is that TROs 1 to 4 would have been, that decision would have had to have been delayed until they were all ready to be made together.
TR5, yes.
That, if that had happened, then the challenge to TROs 1 to 5 would have then been brought, because we know there's a challenge to TRO 5. The grounds, some of them overlap with these ones, some of them are different. But the claimant would then have been able to challenge those orders as a whole. If this court were to rely on the future making of TRO 5 in order to defeat this claim, there would be substantial prejudice to the claimant, because the appellant's position is that TRO 5 is ultra vires. And so when it comes to discretion, in my submission, it's relevant that TRO 5 is under challenge and hasn't been relied upon by the respondent as a reason to uphold the decision. Because had it been relied upon, my lord, this court would have submissions on that challenge. It may have been that the appellant would have sought to have had that challenge expedited before these hearings.
Okay, anyway, we've got that, yeah.
So, my lord, ground 3, the general point was made that you can't read across evidence and decision making about the scheme and apply it to the TROs, which are more narrow. My lord, the TROs could not be considered in a vacuum. So when making a one-way system, a bus lane, there will obviously be attendant the necessity to, in implementing those, perhaps make changes to junctions, perhaps even amend how a junction works. One can't simply step into a no wider scheme world when considering the TROs, because that was never the intention. There was no world in which these TROs would be relied upon by the respondent.
Right, they were
scheme.
part of a scheme and they wouldn't have been made but for the scheme.
Exactly.
Yeah.
My learned friend made points on Venus Care and better streets for Kensington and Chelsea. Well, the simple point is that in none of the cases relied upon by my learned friend was there available to the decision maker technical reports which went to material issues which were material to the decision. So every case will turn on its facts. And my learned friend is incorrect to say that this is, well, just a blanket irrationality challenge. It's not. It's a challenge to findings being unsupported by evidence, the leaving out of account of mandatory material considerations, and to a materially misleading report. My lord, on safety, I think my learned friend said at one point the quality review panel agreed that the critical safety issue did not make the scheme unsafe. My lord, I don't find that anywhere in the quality.
I think he's interpolating. They don't say you mustn't have the scheme because it's unsafe. I think he's interpreting from the fact that they're saying it has improvements because it's separating cyclists from traffic generally, albeit not buses, and that's a good thing. That's what I think, is interpreting.
Yes.
And he may be right, he may be wrong. You'll find out, perhaps.
Yes, and my lord,
give judgment.
one
That's
has
what
to
he's
read.
saying.
Yes.
The words don't appear there.
No, but despite the positive impact, it's noted there's still one unresolved critical issue.
Yep.
My learned friend took the court to page 196 of the bundle, where the release for cyclists was dealt with in response to an objector's concern. My lord, nowhere on that page or in the report is it reported to the decision maker that an independent panel from the West Yorkshire Combined Authority and Active Travel England had that concern. And in my submission, that's the weight of a concern of an independent panel, or that one would expect to be given to the concern of an independent panel. It's very different from an objector raising a concern.
Yep.
On journey times,
Yep.
my learned friend relied upon the phrase rebalancing in the report,
Yes.
paragraph 6.3. But my lord, I just simply asked the court to read those paragraphs in context, which assert that expeditious movement would be maintained.
Yep.
And my lord, on the detailed point where my learned friend says, well, this wasn't relevant to the TROs, and it was 6.2.5, page 108 was relied upon, there being more road space and cycle time dedicated to active travel. Well, it's right, the cycle time is to do with how the junction operates, i.e. how many green lights one has in a minute. But the other part of that is road space being dedicated to active travel.
Yes. And
Which
there'd
is
be one
part
instead
the
of two.
TROs.
Yeah.
And of course, amendments to junctions, you can't separate them out. It would be a nonsense to do so.
Well, the more road space is you've got a one-lane highway instead of a two-lane highway for cars, isn't it? Because one lane's become a bus lane.
That would be one point. Yes, my
So
lord.
it does follow from the TRO.
Well, in my submission, it would be artificial to separate them out, is the short point. On carbon, my learned friend relied on paragraph 11.1 and the phrase seeking to offset.
Yeah.
But later on in that paragraph, the phrase used is the view of officers. The view of officers is that it doesn't have an adverse impact on climate change. So that's it's page 153.
Yeah.
So it's that final sentence. It's a positive assertion. There's no adverse effect on climate change. That then refers the decision maker back to Appendix E.
Yeah.
And it was Appendix E that said it was neutral. And my lord, I make the same point. My learned friend said, well, the WSP carbon report wasn't relevant because it's about the wider scheme. But my lord will remember that even when it came to just looking at user emissions, not construction of any public realm, the user emissions of increased vehicle movement, increased vehicle kilometres.
Well, the thing that I didn't understand this morning, and I remain still puzzled because of the math.
I confess, maybe, my lord, I confess, I went back to the document we received, that is in the bundle.
Yeah, but you see my problem with it.
I do, my lord. What I would say is that this is a report received by the respondent. At no point in this litigation has it said there's something wrong with the report.
No, I understand that, but I mean, you're asking a court to look at it and understand it when I'm saying that I can't understand it.
Well,
it's better to be honest.
Oh, yeah, no. My lord, it may be that there's a typographical error in terms of vehicle kilometres saved. I don't know. But what is very clear from the report is that user emissions are a negative. So when you look at in other words, the modal shift will not offset additional emissions from vehicles.
Yeah.
That's the short point, and it wasn't reported. So, my lord, unless I can assist the court further, there's a message.
No, that's very, very helpful. Marvellous. So we have finished within a day, which is very good from the purposes of the court. Very good from your purposes, because it means we'll have tomorrow to discuss and think about all that you've said. So thank you all very much indeed for your assistance, counsel, but also the teams behind, because it takes quite a lot to get all this quite complicated, which is fine for you. You've got the pleasure of living in Harrogate, and you know these places, so it's easier for you. But we are hugely grateful to all of you for all the help that you've given. What will happen now is that we will want to consider the material and the arguments very carefully, And we know that it's quite an important matter for the people who live in Harrogate and who travel there by bus, by car or walk. And we will try and give a judgment as soon as we possibly can, but we've now got an extra day to think about it. I can't promise you when that will be. The way that judgments work nowadays, so those who are in court understand, we produce a draft of the judgment, which we circulate confidentially through counsel, and they can take instructions from the parties. And that is only for typographical corrections. If we've got the words wrong or a date or something is obviously wrong, it's not to re-argue the whole case. So don't get too excited when the draft arrives. It's a confidential draft. It's subject to an embargo. To disclose the contents to a person to whom it is not authorised to be disclosed is unfortunately contempt and a criminal offence, and the courts take that sort of thing quite seriously, so you can't disclose it. And then after a couple of days, we'll ask you for your corrections and a draft order as to what should happen in the light of what it is that we've decided. And then the judgment will be formally handed down. It used to be physically in court, now it will be electronically, and you'll have a formal handed down judgment which will say what our conclusions are. Doesn't mean that every point will have to be dealt with, only those points that we think are necessary to address in order to give judgment. But it's been a very interesting case. I've learned a great deal about cars, climate change. I already knew a bit about Harrogate, which is a lovely city, or town, although I'm slightly concerned it may not nip out of the Football League. But leaving that to one side, because they're just above us, so they've got a few points to spare. But leaving that to one side, I shan't hold it against Harrogate. But thank you all very much indeed. It's been a pleasure.